Today, more than ever, the Supreme Court holds a vast amount of power in our country. Thanks to case precedent, where the previous majority's holdings often decide how future cases are also ruled, every word in majority rulings holds weight in deciding what the law is. Therefore, the way in which the Supreme Court comes to these decisions is very important, since if it is based on faulty logic, future courts will be forced to perpetuate what is effectively the wrong interpretation of the law. Unfortunately, nowhere in the Constitution does it prescribe a method for the court to interpret the Constitution. Thus, what counts as faulty logic is debatable. Do we consider the practical impacts of a court decision? Only the exact words of the Constitution? The spirit of the text? Do we want to uphold general values of the Constitution or the specific and possibly outdated mechanisms inscribed? Do we care what the intentions of the framers or how the Constitution was understood at the time of founding? All of these questions are ones which a judge has to consider, and for a while, there wasn't one guiding philosophy that judges used to decide a case. This has led to fierce debates about how much power judges should have in interpreting the Constitution, and these continue today. Ironically, these debates are often split down ideological lines, as interpretations that favor the original meaning of the Constitution often favor more conservative policy. Meanwhile, interpretations that favor a modern interpretation of the Constitution favor more liberal policy. Despite the lack of guidance written out specifically in the Constitution, many point to literature published around the time of the ratification as the basis for interpretation. For example, Alexander Hamilton famously wrote in the Federalist No. 78 that the courts must declare the sense of the law, and if they should be disposed to exercise will instead of judgment, the consequence would equally be the substitution of their pleasure to that of the legislative body. This doctrine has been co-opted by scholars as the manifesto of originalism. But what actually is originalism? A quick history lesson. It's important to note the context that originalism has arisen for reasons that will be clear in a moment. In the Warren Court, 1953 to 1969, era, which is considered the most liberal court in American history, many conservatives in America felt as though judges were disregarding the rule of law in favor of judicial activism. Thus, a need to have an objective framework of interpretation arose. The spread of originalism is mostly due to the consolidation of conservative legal ideology in the Federalist Society. Starting as a student-run organization from the top law schools in 1982, the Federalist Society has expanded to the point where, if you want to be a conservative judge or lawyer in appellate law, you need to have connections with the Federalist Society. In particular, the Federalist Society has been instrumental in the spread of originalism. Therefore, the context in which originalism was brought up is a conservative one, but originalism isn't necessarily biased toward one direction, nor should it be discussed as so. With that in mind, what exactly is originalism? The answer is that it varies from scholar to scholar, but the general principles which originalists tend to hold up is there is an identifiable consensus on the meaning of the Constitution. At time of ratification, this meaning has not changed over time, and it's the judge's job to reconstruct it. However, it is not the judge's job to consider the practical implications of their decision, nor weigh any kind of values or policies against each other. In order to uphold such principles, originalist judges will often pull any and all 18th and 19th century sources that can inform the public consensus about the Constitution. The words of the law are then interpreted to mean that same meaning that the judges believe was the consensus at the time of ratification. There are a couple important points to note. First, this was actually not the original objective of originalism at its inception. Originally, conservative scholars stressed that the intent of the framers was the most important to look at, but since then it has been shifted to be the understanding of the people. Second, some people will refer to originalism as textualism. However, these terms are not actually interchangeable. Textualism refers to the method of interpreting which binds the judge directly to the text. No outside sources or historical considerations at all. Meanwhile, originalism does consider the history and contemporary sources of the ratification era. Critics have several problems with originalism. For instance, many object to the premise that there is a true meaning of the Constitution which can be reconstructed. For one, neither the framers nor the public fully agreed on the Constitution, which is why the creation of the Bill of Rights was already in the process before the Constitution was even ratified. The assertion that the public had a consensus on what the Constitution meant is, at the very least, debatable. Another question with originalism is more on the meta layer. How do we know which originalist interpretation is the best? The one which most aligns with history? The principles set out by the Constitution? The intentions of the framers? The answer is not totally clear, and the reason for choosing one metric over another seems to be somewhat arbitrary. A third issue stems from interpretations. What if there are two equally acceptable interpretations? How do we choose between the two? This is another unresolved question. Finally, by trying to apply the public's understanding of a law 250 years ago, it risks upholding values and institutions that we no longer find acceptable, such as slavery and segregation. Of course, there are more objections than the ones I've outlined here, but I've posed these questions to get an understanding of the current discourse going on both within originalist circles themselves and between different schools of thought. Furthermore, many scholars argue that even if there are flaws in originalism, it's still better than the alternative modes. So, what is the alternative? There are actually many forms of constitutional interpretation that have been employed by the courts in the past. These include structuralism, moral reasoning, precedent, and historical practices. However, these modes of reasoning have generally fallen out of favor with the court and usually are only applied in niche scenarios. The main mode of interpretation that is counter to originalism is pragmatism. Unlike originalism, the history of pragmatism isn't as laid out. Various post-Civil War scholars, such as John Dewey and Charles Sanders Peirce, proposed the philosophical idea that meaning of a given concept is only determined by its practical effects, and not the idealized version of it. This idea diffused into the court system over time and has been used variably for a century. Like originalism, however, pragmatism is a spectrum which depends both on the judge and the case at hand. Furthermore, it doesn't exist in a vacuum and will usually involve precedent from other cases. Occasionally, moral reasoning will come into play too. In general, though, pragmatists consider the implications of their decision and usually weigh the harms and benefits of their decision as a part of a ruling. A pragmatist usually acknowledges that the Constitution is outdated and, in areas of vagueness or uncertainty, applies the spirit of the text to fill in the answers. Today, this form of interpretation is most often used by liberal judges and has been termed neo-pragmatism. To many scholars, the use of judicial will is alarming. This type of moral and pragmatic weighing should be left to the legislature. This is playing right into Hamilton's warning that courts, on the pretense of a repugnancy, may substitute their own pleasure to the constitutional intentions of the legislature. Often, these kinds of objections stem from a larger question of what the role of a judge even is, and if a judge can necessarily say what the law is without asserting their will. These are all contentious questions for which the debate continues to this day. To conclude, originalism versus pragmatism is a contested, heated debate which has much literature about it and continues to be debated for the reasons laid above. As it stands, though, it seems a majority of our court system is adopting originalism, and no matter whether you agree or disagree with that decision, it's important to know the mechanisms for which the most powerful legal entities in the country use to rule on the most pressing issues today.